The Supreme Court has just unleashed a judicial earthquake so powerful it has effectively liquefied the ground Donald Trump stands on, plunging the former president and his entire legal team into a state of absolute frozen shock. We are watching a historical pivot point that almost no one predicted, and the consequences for the Trump camp are nothing short of terrifying. Before we untangle the specifics of this legal ambush and explain why reports suggest Trump is spiraling into a panic, I need you to take a brief second to click that subscribe button, toggle on your notifications, and hit the like button on this video. If you are looking for the raw, unvarnished truth about these courtroom battles, details the mainstream news often skims over, you have found your home. Join our growing community right now so you don't miss a single development as this historic 72-hour countdown begins. Now let's dissect the anatomy of this cataclysmic ruling. In a decision that legal historians and constitutional scholars are already labeling as unparalleled in the history of American law, the Supreme Court has decreed that Donald Trump must immediately, without any hesitation or delay, surrender financial records, internal business communications, and sensitive documents that his own lawyers didn't even realize were being targeted. This was not a standard rejection of a seriary petition or a mundane procedural dismissal. This was the highest court in the land, ripping back the curtain to expose a secret. A sealed grand jury investigation has been operating in the dark, running parallel to every known prosecution for over a year. Trump is now legally forced by the Supreme Court to hand over evidence that could unveil a completely new, previously hidden dimension of criminal liability. It is genuinely hard to wrap one's mind around the fact that the Supreme Court successfully kept a proceeding of this colossal importance entirely under wraps for months on end. We are discussing a clandestine legal war waged in the shadows, a secret battle that even Trump's lead defense attorneys were reportedly oblivious to until the gavel came down. The justices released this decision with zero forewarning. There were no televised oral arguments. There were no press releases issued to the media. There was absolutely no window for Trump's public relations machine to spin the story, nor for his legal team to draft a counterstatement. One minute, Donald Trump thought he had a map of the legal minefield he was walking through. He thought he identified every threat. The next minute, the earth opened up and he fell into a legal abyss he didn't even know was there. This isn't just about tossing another case onto the pile of his legal WOs. We are talking about the Supreme Court disclosing that a covert investigation has been active this whole time, one involving evidence so sensitive, so potentially destructive, or so vital to national security that the mere existence of the subpoena had to be classified as a state secret. And believe me, the ramifications of this surprise attack are going to fundamentally rewrite everything we thought we understood about Trump's legal vulnerability and his political horizon. To fully grasp the gravity of this surprise judgment and why it has triggered such pandemonium, you have to understand how incredibly uncommon it is for the Supreme Court to function this way. In the normal course of business, the court is the gold standard of transparency. Cases are placed on the public docket for the entire world to monitor. Oral arguments are put on the calendar months ahead of time, granting both parties ample time to strategize. Briefs are filed in the open, available for journalists, scholars, and the public to scrutinize. Secrets are generally non-existent in the Supreme Court. However, the court does hold the power in exceptionally rare and specific scenarios to hold proceedings entirely under seal. This is a power reserved for moments when the nation's security hangs in the balance or when other extraordinary interests demand total silence. Throughout American history, this authority has been used with extreme frugality, typically restricted to cases involving top-secret classified data, active covert intelligence missions, or situations where public knowledge could inflict immediate, irreversible damage on the country. The fact that they invoke this power here communicates everything you need to know about the severity of this matter. According to the text of the ruling released on December 7th, this sealed saga began more than a year ago. It originated when a grand jury fired off a subpoena demanding Trump's financial archives, his internal business messages, and documents pertaining to what the court's opinion cryptically refers to as matters of significant national concern. Because this subpoena was issued under seal when Trump was served, he was simultaneously gagged. He was legally forbidden from whispering a word about its existence to the public, to his political base, or to the press. His lawyers were shackled by these same rigid confidentiality rules. Now, here is the twist that makes this narrative so unbelievable. Trump apparently fought the subpoena through sealed filings. He waged a war in the dark, recycling the exact same arguments about immunity and executive privilege that he has shouted in his public trials. He attempted to use the same old playbook, but those challenges collapsed. They worked their way up the ladder of the federal courts entirely outside the public eye. The lower court struck down his arguments. The appeals court struck down his arguments. And now the Supreme Court has struck down his arguments in a final devastating ruling that simultaneously exposes the existence of the battle and commands immediate obedience. The court's opinion, written by Chief Justice John Roberts, is direct and merciless. It declares that the subpoena is hunting for documents and records related to conduct that lies completely outside any reasonable claim of presidential immunity. It continues by asserting that the defendant's efforts to stall and obstruct compliance have been fully exhausted through the proper legal avenues, and that no further procrastination will be tolerated. Legal analysts who have been frantically dissecting the ruling's text note that the language implies this conduct is entirely distinct from the classified documents case in Florida, distinct from the January 6th trial in D.C., and distinct from the Georgia election interference racketeering case. This appears to be a separate beast entirely, a fourth major legal front that opened up beneath Trump without the American public ever suspecting it was there. Now, admittedly, this isn't the first time the Supreme Court has ruled against Donald Trump. We have witnessed losses in the past, but what makes this fundamentally unique is the element of total surprise and the unveiling of this hidden dimension. Consider the other rulings. When the court shot down his claims of absolute immunity earlier this year, Trump's team saw it coming from a mile away. They had argued the case in open court. They had months to concoct alternative legal theories and media spins. That ruling was a hit, sure, but it was a telegraphed punch. When the court ruled back in 2020 that Trump's tax returns could be seized by New York prosecutors, again there was no shock. That war had been fought in public for years. Trump's attorneys had time to formulate responses to war game, the consequences, and to prepare for the aftermath. Even the historic Watergate-era decision in United States versus Nixon, which compelled the president to surrender the White House tapes, arrived after exhaustive public litigation. Nixon knew the case was barreling toward him. He knew exactly what was on the line. He had time to weigh his choices, including the ultimate choice to resign, before the tapes destroyed his presidency. This ruling is structurally and fundamentally different. Trump's team had no clue this sealed proceeding existed at the appellate level in this specific configuration. They had no chance to brace themselves for this specific result on this specific day. They woke up this morning believing they possessed a complete map of Trump's legal tribulations. By lunch, they discovered the map was a lie. According to reporting from the New York Times on December 7th, Trump's lead attorneys found out about the ruling from breaking news alerts, not from the court itself. The sealed nature of the process meant that even standard notifications were embargoed. One insider depicted the atmosphere at Mar-a-Lago as absolute pandemonium, with lawyers scrambling frantically to figure out which documents were even captured by the subpoena and what the timeline for compliance actually demanded. Then we must look at the pattern of how Trump usually reacts. When he encounters a setback, he goes on the offensive. When the immunity ruling dropped, he attacked the justices. When lower courts ruled against him, he filed immediate appeals. When evidence surfaced in the classified documents case, he alleged it was planted. His strategy has always been attack, delay, delegitimize, but this ruling leaves almost zero oxygen for that strategy. The subpoena has already been litigated through every single tier of the federal judiciary. The Supreme Court's decision is final. There are no more appeals to file. There is no higher court to cry to. The deadline for compliance, according to the ruling, is exactly 72 hours from the moment the decision was released. We are not talking about weeks. We're not talking about months. We are talking about 3 days. And the court added a detail that legal experts are calling extraordinary. The opinion explicitly states that any failure to comply fully and in good faith will trigger immediate civil and criminal contempt proceedings with sanctions that include potential pretrial detention. The court is essentially holding a loaded weapon to his legal temple, warning Trump that if he attempts to stall, obstruct, or provide half-baked responses, he could be thrown in jail pending trial. This reflects a court that has completely run out of patience. They have watched him attack judges, defy orders, and treat the American legal system like a political campaign stop. This ruling signals that they are finished tolerating it. Before we unpack exactly what is hiding in these documents and why they pose such a danger to Trump, I want to take a brief moment to ask you to support this channel. If you appreciate deep dive analysis that actually connects the dots and explains the why behind the headlines, please smash that like button right now. Leave a comment down below. Do you believe Trump will comply, or will he try to defy the court? Share this video with your friends and family members who need to grasp the reality of this situation. Your engagement is the only way we break through the algorithm to deliver the truth. So, what exactly is this sealed subpoena demanding? Why is Trump's legal team in a state of total meltdown? It all comes down to a scope of document requests that appears far wider and more destructive than anyone dared to guess. According to excerpts from the subpoena that were included in the court's now public ruling, prosecutors are hunting for three distinct categories of evidence. First, they are demanding complete financial records from Trump's business empire stretching back to 2015. This dragnet includes every transaction involving foreign entities, all loans, and their specific terms, and all communications regarding property valuations. This strikes directly at questions of financial fraud and potential money laundering that have hovered around Trump for years, but have never been definitively proven in court. Second, they are demanding all communications between Trump and certain foreign nationals whose names remain redacted in the public version of the ruling. The court's opinion cites national security concerns as the reason for keeping these names under lock and key. This isn't just about business partners. This implies involvement with foreign governments or intelligence matters. Legal analysts are theorizing this could involve anything from business deals with Russian oligarchs to back-channel discussions with foreign officials during and after his presidency. Third, and perhaps most explosive, the subpoena seeks documents related to what the ruling describes as efforts to obtain things of value from foreign sources in connection with electoral activities. This language mirrors federal statutes almost verbatim that prohibit foreign contributions to American political campaigns. This could signal an investigation into whether Trump or his campaign solicited or accepted illegal foreign assistance, a charge that strikes at the very heart of democratic integrity. Now, this is where the situation becomes excruciatingly complicated for Trump's defense. These document categories overlap with but extend far beyond his existing cases. The demand for financial records could yield evidence relevant to the New York civil fraud case, but it could also unearth entirely new instances of fraud or illegal activity that haven't even been charged yet. The demand for foreign communications might relate to known investigations, but the national security classification hints at something much more sensitive. Trump's attorneys are trapped in an impossible position. They have a mere 72 hours to compile and surrender documents that span nearly a decade of complex business activities and communications. They may not even know which documents exist or where they are physically stored. They are tasked with reviewing potentially millions of pages for privilege claims, all while knowing the court has already signaled it will tolerate zero delays. According to sources who spoke with Politico on December 7th, Trump's legal team convened an emergency meeting within hours of the ruling to assess this compliance nightmare. One attorney reportedly described the task as being asked to empty the ocean with a teaspoon. The sheer volume of responsive documents is massive. The timeline is impossibly tight, and the consequences of non-compliance are imprisonment. But the logistical nightmare is only a fraction of the problem. The substantive threat is far worse. Whatever Trump has been concealing in these documents, whatever he fought so desperately to keep secret through a year of sealed litigation, is about to be exposed to the light. And given the extraordinary measures taken to keep this proceeding confidential, prosecutors clearly believe these documents contain something devastating. Now, this is where things began to go terribly wrong for Trump's already fragile mental state. According to multiple reports, including coverage from CNN and MSNBC, Trump's reaction to the ruling was volcanic. Sources depict him screaming at his attorneys, hurling objects, and demanding to know who betrayed him by allowing this secret proceeding to advance without a successful defense. But there was no betrayal. His attorneys did fight the subpoena. They simply lost at every single level in proceedings they were legally forbidden from discussing in public. The secrecy that Trump usually employs to his advantage, controlling the narrative through media manipulation, worked against him here. He couldn't rally public support for a fight the public didn't know was happening. Then, predictably, Trump made the situation worse. Within hours of the ruling, he took to Truth Social and began attacking the Supreme Court justices, including the three he appointed himself. He branded the ruling a sneak attack by corrupt judges. He suggested Chief Justice Roberts was compromised. He claimed the entire proceeding was unconstitutional and explicitly stated he would not comply with an illegitimate order. Legal experts immediately sounded the alarm, warning that these statements could be weaponized as evidence of intent to defy a lawful court order. If Trump follows through on his threat to not comply, prosecutors can point to these social media posts as proof that his noncompliance was willful, not the result of logistical hurdles or good faith disagreements about the subpoena's scope. According to former federal prosecutor Andrew Weissman speaking on MSNBC, Trump's public statements are practically a written invitation for contempt proceedings. Weissman noted that when a defendant announces publicly that they intend to defy a Supreme Court order, prosecutors don't have to struggle to prove intent. The defendant has already confessed to it. This leaves Trump in a corner where every single exit leads to disaster. If he complies with the subpoena and surrenders the documents, he is handing prosecutors evidence that could reveal entirely new criminal liability. Whatever he has been hiding is about to become part of the official record. If he defies the order, he faces immediate contempt proceedings. The court, Snorts has already warned that sanctions could include pretrial detention. Trump could find himself sitting in a jail cell, not for any of the crimes he has been charged with, but simply for refusing to obey a lawful subpoena. That would be an extraordinary spectacle. A former president imprisoned for contempt while his criminal trials are still pending. If he tries to delay through procedural tricks, the 72-hour deadline makes that nearly impossible. There is no time for new motions. There is no time for new appeals. The Supreme Court has spoken. The matter is closed. Compliance is mandatory. It is a trap with no escape hatch. And it is entirely a trap of Trump's own making. Whatever is in those documents, he could have turned them over a year ago when the subpoena was first issued. Instead, he fought and lost at every level, burning time and money while the evidence remained out of prosecutors' hands. Now he has zero options left. This entire scenario is sending shockwaves through Trump's political and legal circles because the revelation of this secret proceeding raises terrifying questions about what else might be happening behind the curtain. According to reporting from the Washington Post on December 7th, Trump's allies are in a state of near panic, trying to determine if there are other sealed proceedings they are unaware of. If one secret investigation could reach the Supreme Court without public knowledge, why not others? What else is the Department of Justice pursuing that hasn't been revealed? This uncertainty is psychologically devastating for Trump's defense strategy. For months, his attorneys have been planning around the known cases, classified documents, January 6th, Georgia, New York. They have allocated resources, developed strategies, and coordinated timelines based on the belief that they understood the full scope of Trump's legal exposure. Now, they have learned that their understanding was dangerously incomplete. Things became even more chaotic when reports surfaced that at least two attorneys on Trump's legal team are considering withdrawing from the case. According to sources who spoke with CNN, these attorneys were not fully informed about the sealed proceeding because of the strict confidentiality requirements. They are now questioning whether they can ethically continue representing a client who may have withheld crucial information from them or place them in ethical jeopardy. Attorney withdrawal at this stage would be catastrophic. New counsel would need months to get up to speed. The 72-hour compliance deadline doesn't pause for staffing changes, and Trump's already damaged reputation within the legal community means finding qualified replacements will be extremely difficult. Meanwhile, the attorney who previously cooperated with prosecutors, the one who provided the leaked audio recordings, is reportedly providing additional context about the sealed subpoena. According to sources familiar with the matter cited by Politico, this cooperating witness possesses knowledge of specific documents Trump tried to hide and can testify about conversations where Trump discussed what would happen if these particular records ever saw the light of day. If this is true, it means prosecutors don't just have subpoena power, they have a roadmap. They know exactly what to look for. They can compare what Trump turns over against what the cooperating witness says should exist. Any missing documents, any suspicious gaps will be immediately apparent. Let's talk about what this ambush ruling implies for Trump's actual legal exposure, because the implications extend into territory that hasn't been publicly discussed until now. First, the financial records demand suggests prosecutors are building a case that goes far beyond the known fraud allegations. The New York civil fraud case focused on inflated property valuations for loan and tax purposes, but this subpoena's scope, going back to 2015 and covering all foreign transactions, suggests an interest in something more. Legal analysts are speculating about potential money laundering, unreported foreign income, or violations of the Foreign Corrupt Practices Act. According to tax law experts who spoke with CBS News, the breadth of the financial records demand is extraordinary. They noted that prosecutors typically narrow subpoenas to specific transactions or time periods. Asking for everything since 2015 involving foreign entities suggests they are looking for patterns of systemic conduct, not isolated incidents. Second, the demand for communications with redacted foreign nationals raises the specter of counterintelligence concerns. The court's citation of national security interest for keeping these names sealed isn't routine boilerplate language. It suggests these individuals may be connected to foreign intelligence services or may be subjects of ongoing national security investigations themselves. Some legal observers are drawing lines connecting this to long-standing questions about Trump's relationships with foreign powers, his unusual deference to Vladimir Putin, his private meetings with foreign leaders where no American officials were present, and his handling of classified information in conversations with foreign nationals. These questions have never been fully answered, and this subpoena may finally produce the documentary evidence to answer them. Third, the reference to obtaining things of value from foreign sources in connection with electoral activities suggests an investigation into campaign finance violations at a level beyond anything previously disclosed. Federal law strictly prohibits foreign nationals from contributing to American political campaigns, and it prohibits American campaigns from soliciting or accepting such contributions. If Trump or his campaign received foreign financial support, that is a serious federal crime. According to campaign finance experts interviewed by MSNBC, the specific language in the court's ruling tracks very closely with the statutory prohibition. They noted that prosecutors don't use this precise phrasing by accident. It suggests they have evidence of potential violations and are seeking documents to confirm or expand their case. The combination of these three categories, financial records, foreign communications, and evidence of potential foreign campaign support, paints a picture of an investigation that is far more serious than even Trump's existing criminal cases. This isn't just about mishandling documents or trying to overturn an election in the open. This is about potential corruption at the intersection of money, foreign influence, and American democracy. Legal scholars are already weighing in on the constitutional and historical significance of this moment. Lawrence Tribe, the renowned Harvard constitutional law professor, posted on social media that this ruling may represent the most consequential Supreme Court decision regarding a former president since United States versus Nixon. He noted that while the sealed procedure is extraordinary, It is apparently justified by national security concerns that we may not fully comprehend for years. But here's what really caught my attention. Conservative legal commentator Jonathan Turley, who has often defended Trump in the media, appeared on Fox News and acknowledged that the ruling presents what he called an existential threat to Trump's legal position. Turley noted that the existence of sealed proceedings suggests prosecutors have evidence of conduct serious enough to justify extraordinary confidentiality measures. That is not a good sign for Trump when even sympathetic legal analysts can't find a way to minimize the damage. You know you are witnessing something historic when the defense's usual champions are at a loss for words.